All rise.
Kosovo Specialist Chambers is now in session.
Good afternoon, Your Honors. This is case KSC BC 2020-05, the Special Prosecutor versus Salih Mustafa.
Thank you. I will now call appearances. Mr. Prosecutor, could you tell us who's present for the Specialist Prosecutor's Office?
Of course. Good afternoon, Your Honors. Good afternoon, everyone. The prosecution is represented today by Silvia Dascoli, Associate Prosecutor, Julie Mann, our case manager, and myself, Cezary Michalczuk, the prosecutor of the SPO. Thank you.
Thank you. I note that Victims' Counsel is joining us via video link. Does the connection work well, Victims' Counsel?
Yes, good afternoon, Your Honor. Good afternoon, everybody. Indeed, I can hear you very well. I can see you very well. And so I can confirm that the participating victims are this afternoon represented by myself, Annie Poos, as Victims' Counsel, joining remotely.
Thank you. Defense Counsel, you have the floor.
Good afternoon, Your Honor. Defense is represented by myself, Julius van Bonnet, my co-counsel, Mr. Betim Shada, Fatmir Pillai, investigator and interpreter, and joining remote is Mr. Mustafa.
Thank you
very much.
Mr. Mustafa, does the connection work fine? Can you hear me well?
Yes, Your Honor.
And now the registry.
Good afternoon, Your Honors. Good afternoon, colleagues. Jonas Nilsson, Judicial Services Division Registry.
Thank you. For the record, you are appearing before Trial Panel 1. Today we resume the Defense Preparation Conference and the Victim Status Conference with the panel rendering a number of oral orders related to the management of proceedings, including under Rule 119 of the rules. Before rendering these oral orders, the panel wishes to hear the parties and the Victims' Counsel on the matter raised today by email sent to the parties and the Victims' Counsel through CMU at 11:34 a.m. And in this email, the panel requested the defense to make submissions on the relevance of the expected witnesses 100, 1800 and 2000 to the charges against the accused. The panel also invited the SPO and the Victims' Counsel to make submissions in this regard, should they wish to do so. Defense Counsel, you have the floor.
Thank you very much, Your Honor. I won't be very lengthy, but let me start with the gentleman indicated with number 100. Strictly speaking, he cannot say anything directly related to the charges. Let me put that first, because he was not in contact with Mr. Mustafa or at the place. Having said that, we believe that he is relevant because he can provide very well context of the conflict and how to understand it from the viewpoint of the population of Kosovo. He was a member of the General Staff and he has had the overall scope of what was going on at the time in the several operational zones. At the same time, he participated in the meetings, and in that context he can say something about command, compliance and orders, and to who were they given, and in what way they would have feedback. As the head of the Public Relations and Civil Administration Department, he also was in a position that he was having very good contact with what was going on in the civilian side of it. Therefore, we believe that he could testify about that. BIA was operating mainly in the civilian area of Pristina, operating for the civilians. And this gentleman, he was in the best position to hear anything, getting feedback from the civilian population regarding all kinds of things, including that if people would have been detained, where they would have been detained, or whether they would have made any make any claims regarding any people who were missing at the time or at a particular period. Especially for us, obviously it's relevant for the period of between 1 and the 18th or 20th of April, to be exact. So we believe that even though this gentleman is not strictly a person that we can say he knows about anything about the specific charge, he can provide us context. And so far we believe, Your Honor, that we lack, in fact, context in this side from anybody in the position of the General Command point of view. So I think that is a very useful person to have. I move on to the other gentleman, which is the number 1800. This person is a person that was wounded in and near Salih, and has been treated in Salih we believe on the location which is specific to the charges. And the question is, in fact, whether the context given at this moment by the prosecution, that location, that is the key of the entire case, that location would be a location run by the BIA. They would be the persons in charge for it, and so on. We truly believe that the work that was done at that location, or work is not good. It's not really a good word in this particular context. Treating wounded was one thing. This person was also participating in the hostilities leading up to the offensive, and I think he is in a good position to talk about the offensive, when it started, where it started. We have a good idea. That is the location where it came from, more or less from that time on. His main location is Salih and Bramor. Those are the two locations. I think these are the locations. We locate Salih as part of Bramor, but in fact Bramor is, village-wise, on a different locations than the location that we are talking about in question. And I'm speaking about the compound. So, this person was treated at that time by two other people, and that were the witnesses number 1600 and 1700. So we have two people who are treating it from a professional point of view, and the third one is the patient, so to speak. And we do believe that it's all on one and the same location that they were working, and that would obviously give an entire different scope and view of what in fact the buildings on the compounds were used for, who was there, who was present, and so on. And this is one of those persons, we believe, who was there. The last person, Your Honor, is number 2000. And number 2000, the pre-trial brief, the SBO mentioned that it was the BIA who would run, specifically written like that, run detention centers within the LAP operational zone. We truly believe that is absolutely not the case. What we have here with this witness is in fact a person who was a military police officer. He was in the command of the military police, and in fact he was in charge and working with the detention center, which was in La Pasticha area. So in his testimony, it is clear how he documented that, and we believe that he had never contact with either a BIA person or somebody who would have been sent by BIA to that particular detention center of which he was in charge. And he is very clear about all the ways and means that the military police handled that particular detention center. So that is in fact the single person that we found, and we believe that as we are speaking about a detention compound here, then we actually want to know, okay, if that is that detention compound, where was it actually? Was it in La Pastiche? Was that the single one? Or was there any other one? That is, this person can clearly indicate the details about that. Yeah, obviously as a military police member, he knew about the role, the authority of the military police, and the people who would have authority or would have not at all any authority to either arrest, detain, or facilitate any kind of detention compound. The key in this entire case for us is that as Mr. Mustafa is being charged with these crimes, mainly having people detained, having them under specific conditions, and torture them or maltreat them in any manner, we do not believe, in fact, that Mr. Mustafa had anything to do with that. And he's very clear in his denial. He has nothing to do with it, and he did not for nothing plead not guilty to the charges. He is very strong in that. We truly believe that he is an innocent man, and that he, in fact, had nothing to do with any kind of detention of any of the victims or people who might have been detained at some point and who have testified in this case. So basically, if there was any kind of detention, then we can better look at where was the detention, how was that done, how did the KLA actually operate that, how was that regulated, and were there any people? Was there any influx in this particular detention center where this man was, how can I say that, operating and coordinating everything? Was there any influx, and from who, and for what reason would those people have been detained? So basically those are the submissions that we have on these three issues, and that's my conclusion for it. Thank you very much.
Thank you, Counsel. I look at my right side. Are there any questions? No. Good. Then, Mr. Prosecutor, would you like to raise anything in this regard?
Yes, Your Honors, a few remarks on this issue. I'm not going to repeat our arguments that we put in our submission dated 7th of March 2022. It's the filing number F00338. In that submission, we referred to witness number 100 and witness number 1800. And we indicated that after having reviewed their statements given to the defense, we believe that the value of their statements is indeed marginal to this case. Some of the, and maybe I should just discuss these witnesses one by one, very, very briefly, as my learned colleague has just done. In relation to witness number 100, he talks about many matters which are very interesting indeed. They give a certain historical context. He talks extensively about conference in Rambouillet, his role in the Kosovo Liberation Army. However, Your Honors, we believe that as we have the panel's decision on the adjudicated facts, most of the things dealing with the Kosovo Liberation Army, its structure, existence, chain of command, and other things, we already have in that decision. And I'm referring specifically to Your Honor's decision dated 7th of September 2021, number KSC BC 2020-05 F00191. So in a nutshell, we believe that we don't really need this witness, and if this witness is not called by the defense, in the context of the entirety of the evidence proposed by the defense, it will not be prejudicial to the accused in any way. In relation to the second witness, number 1800, we've got to take, we have reviewed before today's session, we have reviewed again the defense statement of this witness, and we believe that the value of the evidence of this witness is again marginal to the case. First of all, he doesn't mention the accused being there, and he speaks mainly about the fact that he was wounded at some point. I believe it was the 18th of April, so at the very, very end of the indictment period, and shortly after, he was treated, true, in Slash by one of the witnesses proposed by the defense. But on this issue, for instance, that witness that we don't oppose, that witness could authoritatively and comprehensively speak about. That's why we think that the defense, if this witness is not called, again, this would not cause any prejudice to the defense and to the defense's case. Speaking about the last witness we are talking about today, witness number 2000, he was the military police officer in La Paștiță, and he mainly speaks about his experiences, his position at that location. He doesn't mention Slash apart from one line where he said that he was in Slash only in 2018, so many years after the events in question. He doesn't mention the accused in the context of the conflict. He says that he met him only after the war. In view of all this, we believe that also the evidence to be given by this witness is of marginal importance. The relevance of these witnesses could be only circumstantial, but it's not really relevant to the charges against the accused in this case. That's why we are of the view, and I think we made it rather clear in our submission before this session, that we don't think that these witnesses should be called. And again, the fact that we will not call these witnesses will not be in any way prejudicial to the defense and the defense case. Thank you.
Thank you, Mr. Prosecutor. Victims' Counsel, would you like to make any observation?
Thank you, Your Honours. Only very, very briefly. So I endorse what the SPO has just been explaining, and would only want to add one additional thought with regard to the last of the three discussed witnesses, witness 2000 or 2000. And to me, the most striking aspect is that he stated that he only heard about the BIA unit after the war. And this, to me, suggests very strongly that given that the defense doesn't raise any doubts that BIA existed as a unit, he is not a source which will help us find out what this unit and what the accused as part of this unit may have been doing. That's all. Thank you.
Thank you, Victims' Counsel. I would like to proceed now to, if necessary, a second round. Defense Counsel, would you like to have the floor?
Very briefly, Your Honor, we believe, first of all, that it is very useful to provide context to the entire conflict, and also context from the civilian point of view. We have for that a person who was in the general staff, who is at meetings, who knows how things are going. I don't think that we would say that that would be marginal. As far as witness 1800 is concerned, Your Honor, I think it makes the picture of the previous two, 1600 and 1700, complete. And these are real people. People were wounded who know, who were standing there with their feet on the ground and who were in the offensive. So I think from a perspective, we do not have such a perspective at all, only in a more global, not really, not a particular manner in which we can say, hey, here we have a soldier who was actually, what happened? How was that offenses? How did that work? We speak in this case, like in many war crimes cases, about many people who died, obviously, or people who get wounded. And we hear from people here in court, sometimes the perspective from people who were victim of whatever kind of maltreatment or whatever. But we have here somebody who was, as a KLA soldier, wounded. And how did that happen? How did that logistically, in fact, work? And where was he treated? We think that perspective lacks. And once again, he is closely connected to witness number 1600 and 1700. It makes that picture complete. And we also think it's not really, it is, these three are actually connected to each other. We thought it would be useful, and it's not the one that we are going to put the most time in, obviously. But it will be, I will believe that it will make it, how can I say, the circle will be around on the topics that the previous two witnesses will have testified about. And lastly, yeah, even though this person might not have been in Salih in the period of the indictment, we do get a conclusive answer on the fact whether there were any detainees at all coming from Salih. Where did the people who were detained in La Pastiche, where did they come from? Who arrested them? Who had such authority? And how would that person be transferred there? Or do we really think that these were only people who would be in the La Pastiche area being detained there? There must have been something for that. We believe that gives a component that we are lacking in the case, and that's why we stand by that witness as well. But that's, of course, it's your panel that will decide.
Thank you, Defense Counsel. Mr. Prosecutor, would you like to react on that without repeating what we have been...
Just very briefly, maybe on the last issue of La Pastiza, the existence of the detention center in La Pastiza does not exclude in any way the existence of detention centers in other parts of Kosovo. So I don't think that by keeping this last witness, 2000, we would get very far in this particular case in relation to Salih. Also, the existence of the La Pastiza and other centers is not a contested issue, really, also in view of previous judgments and cases in Kosovo, run by ANMIC and ULEX. So, in general, we maintain our position that these three witnesses are not really relevant, and their evidence, if any, is marginal to the case and to the charges against this accused. Thank you.
Thank you, Mr. Prosecutor. Victims' Counsel, would you like to add something?
No, thank you.
Very well. If everything has been said, the panel notes, I see you nodding, Defense Counsel. We have taken note of your submissions. The panel will adjourn now for deliberation. We will be back as soon as possible in order to render our oral orders. CMU will inform you as soon as the panel will resume its hearing. Yeah, the hearing is adjourned.
All rise. All rise.
Sejít na kamp.
Further deliberate, I will call appearances now. Yes, Mr. Prosecutor, you are...
We are in the same composition.
Thank you very much. And I see the Defense Counsel via remote link, and the Defense Counsel is also present in the same composition, and Mr. Mustafa is with us also via video link. And the registry is also present in the same person. Thank you. I will now issue a number of oral orders. After hearing from the parties and the Victims' Counsel, both in writing and orally, I will render the following oral orders. The first order relates to the presentation of the evidence requested by the Victims' Counsel. The panel notes the request made by Victims' Counsel in filing 297 and 334 to allow victim 05 to present his views and concerns before the panel. That's the first request. And to appoint an expert in order to medically assess the physical and psychological damages and injuries suffered by victims 8, 9, and 10 as a result of the torture, cruel treatment, and arbitrary detention to which they were allegedly subjected. And that's the second request. With regard to the first request, the panel considers it appropriate to allow victim 05 to present his views and concerns before the panel on Monday, 21st of March 2022 at 9:30 for 1 hour. The Victim Counsel will also be allowed to make submissions before and or after victim 05 has presented his views and concerns for a total of 1 hour. The panel specifies that victim 05 will appear before the panel with only the protective measures vis-à-vis the public as granted by the pretrial judge in paragraph 54 under E and F on the second decision on victims' participation, which is filing 105, and paragraph 51 under F of the second decision on the specialist prosecutor's request for protective measures, which is filing 53. The panel also recalls that pursuant to paragraph 37 of its decision on victims' procedural rights during trial, and that's filing 152, the presentation of views and concerns by the victim 05 will not be subject to examination and cross-examination by the parties and will not be considered as evidence by the panel, unless it considers it necessary to call victim 05 as a witness in accordance with Rule 132 of the rules. With regard to the second request of the Victims' Counsel, the panel appoints the Dutch Forensic Institute to assess the psychiatric condition and to medically assess the physical and psychological damage and injuries suffered by victims 08, 09, and 10 as a result of the alleged torture, cruel treatment, and arbitrary detention to which they were subjected, and to prepare a report accordingly. And to this end, the Dutch Forensic Institute may assign one or more experts as necessary with conducting the required psychiatric, physical, and psychological examinations. The report shall also include information regarding the expertise of each of the assigned experts. And the registrar is requested to make the necessary arrangements to liaise with the Victims' Counsel in order to facilitate the access by the Dutch Forensic Institute to victims 08, 09, and 10. And should any difficulty arise in the implementation of the present order, the registry and victims' counsel are, as the case may be, are directed to seize directly and immediately the panel. And the report shall be submitted by Friday, 13 May 2022, and shall be made available to the parties and the victims' counsel with redactions if necessary. However, the panel and the victims' counsel shall also receive an unredacted copy of the report. And upon submission of the report, the procedure laid down in Rule 149, paragraph 2 till paragraph 5 of the rules shall apply. The decision to appoint the Dutch Forensic Institute to undertake the medical assessment and prepare the report is without prejudice to the final determination of the panel as to the guilt or innocence of the accused, and to any reparation order that may stem therefrom. This concludes the first oral order. The second oral order concerns the opening of the defense case and the presentation of the evidence by the defense. Having heard the submissions of the defense on its readiness to start with the presentation of its evidence, the panel sets Tuesday, 22nd of March at 9:30 as the date for the opening statements, pursuant to Rule 126, paragraph 2 of the rules. The defense shall have 2 hours to make its opening statement and shall be allowed to use visual aids and other tools, including disclosed evidentiary material, provided that this material, including the ERN, is communicated to the court's management unit, the SPO, victims' counsel, and the panel at the earliest opportunity, and in any case no later than Tuesday, 15 March 2022. Any objection to the use of such material shall be raised in a filing no later than Thursday, 17 March. With regard to the presentation of the evidence by the defense, pursuant to Rule 119, paragraph 3 of the rules, the panel orders the defense to remove witnesses 100, 1800, and 2000 from its list of witnesses. The determination of the panel in this respect is based on the statement of these witnesses, the summary of their anticipated testimony provided by the defense in its list of witnesses, as well as the submissions received in court. In particular, the panel considers that the expected evidence of witness 100 essentially relates to political developments in Kosovo and falls outside the temporal framework of the charges against the accused. The panel finds that the expected contextual evidence to be elicited from this witness will not assist the panel in assessing the particular facts of this case. And in addition, the panel finds that the expected evidence concerning the role and functions of this witness within the KLA General Staff bears no connection to the temporal, geographical, and material scope of the case before the panel, as also acknowledged by the defense. With regard to witness 1800, the panel notes that the expected evidence of this witness is repetitious of the statements of other 2 witnesses who are proposed by the defense, witness 1600 and 1700. In addition, the panel notes that witness 1800 was not present in Slash at the time of the events charged against the accused, except on 18 April 1999, and does not provide any relevant information on the accused. With regard to witness 2000, the expected evidence of this witness relates to the structure of the military police of the lab operational zone based in La Pastiche, as well as the detention center based there, hence falling outside the geographical scope of the case. And in addition, the panel notes that the witness has met the accused only after the events charged in the confirmed indictment, and he was not present in Slash during the temporal framework of the charges. In light of the above, the panel finds that the expected evidence of witness 100, 1800, and 2000 is irrelevant to the charges against the accused and therefore not conducive to the determination of the truth. ordering the defense to remove these witnesses from its list of witnesses does not prejudice the rights of the accused to present his case. And to the contrary, the panel authorizes the defense to call witness 200 to 1700 and 1900 proposed in its list of witnesses, which is Annex 1 to filing 333, on the basis that the expected evidence of these witnesses is relevant to the charges against the accused. However, the panel finds that the time estimated by the defense for direct examination of these witnesses is excessive. The panel specifically recalls that the defense does not have the burden of proof in these proceedings and notes that the expected evidence of several defense witnesses is quite focused and relates to discrete topics, which do not require a large amount of time to be dealt with. Accordingly, the panel finds it appropriate to allocate to the defense a total of 36 hours for direct examination of the 17 witnesses authorized to testify. And the overall time may be divided among the witnesses at the discretion of the defense. However, the defense may not carry over time not used with one witness to another witness. And should the defense require more time for a particular witness, it is instructed to make a request to this effect with reasons. The panel considers that this allocation of time is proportional to the total amount of time effectively used by the SPO in the direct examination of its witnesses, and therefore constitutes a fair compromise that respects the rights of the accused to present his case to the panel. The panel also sets Wednesday, 23rd of March at 10:30 as the date to begin 9:30. Not 8:30, 9:30, as the date to begin with the testimony of the first witness by the defense, witness 200. The testimony of witness 200 will continue, if necessary, on Thursday, 24th of March in the morning for one session from 9:30 to 11, and on Monday, 28th of March, starting at 9:30. The testimony of witness 200 will be followed immediately after by the testimony of witness 300 and witness 400, with witness 500 on standby. The panel intends to sit from Monday 28th of March through Thursday 31st of March from 9:30 till 4 every day. For the subsequent weeks, in principle and depending on the courtroom availability and public holidays, the panel intends to sit for 3 days a week from 9:30 till 4. And a more precise schedule will be communicated to the parties and Victims' Counsel by email through the Court Management Unit by the end of this week. In light of the above, the panel orders the defense to file by Monday, 14 March 2022, an updated order of testimony of the 17 witnesses authorized to testify, with the proposed time estimate for the direct examination of each witness recalculated on the basis of the 36 hours allocated to the defense. And this concludes the second oral order. The next oral order set out some deadlines for the defense with a view to properly organizing the proceedings. The panel notes the defense submission that at this stage it does not intend to request the admission of evidence pursuant to rules 153 to 155 of the rules, but that it might make a request to this effect should the need arise. The panel therefore orders the defense to submit by Friday, 18 March 2022, its request, if any, for admission of material under rules 153 till 155 of the rules, or any other provision of the law or the rules. Should the defense maintain its position not to seek admission of any material in writing, but only to present material during the examination of witnesses, no action is required. The panel also notes the defense submission that it is in the process of assessing whether it is necessary to request protective measures in respect of one witness included in its list of witnesses. And in this regard, the panel orders the defense to submit by Monday, 28th of March, its substantiated request, if any, for protective measures in relation to the witnesses at issue. And should the witness at issue be witness 100, 1800 or 2000, who will not be heard by the panel, no action by the defense is required. And the panel further notes the defense submission that there might be some photographic material, statements or documentary evidence yet to be disclosed, but that at this stage the defense does not foresee such possibility. Okay. In compliance with Rule 104, paragraph 5 of the rules, and pursuant to Rule 9, paragraph 5 under A of the rules, the panel orders the defense to disclose any remaining material it intends to rely upon in the course of its case by Friday, 18 March, and to request the amendment of its list of exhibits accordingly, pursuant to Rule 119, paragraph 5 of the rules. Should the defense not wish to disclose any additional material at this stage, no action is required. Any subsequent late disclosure and request for amendment of the list of exhibits shall be motivated. And this concludes the third oral order. The next oral order concerns the irregularities identified yesterday by the panel in relation to the defense list of exhibits. The panel considers that an orderly organization of the defense evidence enhances clarity and facilitates the accurate reading of the defense evidence by all participants. Accordingly, the panel instructs the defense to revise its list of exhibits as well as the metadata uploaded in legal workflow, and to ensure that all information is accurate and complete. The defense shall thereafter file a corrected version of its list of exhibits by Friday, 18 March. And should the defense require assistance in implementing the panel's order, it is instructed to liaise with CMU. And should the SPO or the Victims' Counsel identify any further issues before the 18th of March 2022, they shall liaise with the defense directly. And this concludes the oral order on this matter. Then the last oral order for today, that concerns Annex 1 to the Victims' Counsel submission for the purpose of this status conference. Considering that, in the view of the panel, not all the content of these submissions warrant the ex parte classification, the panel orders the Victims' Counsel to file by Friday, 18 March, a confidential redacted version of filing 334, Annex 1, or to file submissions on why the document must retain the current ex parte classification. This concludes the fifth and last oral order for today. I will now turn to the parties and the Victims' Counsel in order to see if they want to raise any further issue. Mr. Prosecutor.
Your Honor, no comments on the part of the prosecution.
Thank you. Victims' Counsel.
No, thank you. No further remarks. All is clear. Thank you.
Okay. Is there something that the registry would like to mention?
Thank you, Your Honor. Nothing from us.
Thank you. Defense Counsel, is there something you would like to raise at this moment in time?
No, thank you, Your Honor.
Okay. Then we will resume the trial on 21st of March at 9:30 with the views and concerns of victim 05 and the submissions of the Victims' Counsel. I thank the parties, the registry, the Victims' Counsel for their attendance. I thank the interpreters, the stenographer, the people of the audiovisual booth, and the security for their assistance today. The hearing is adjourned.
All rise.